Hi there, how are you doing? In today's class, we are basically going to be looking at administrative law, and we are going to be looking at an interesting topic known as natural justice. So basically, we are going to be looking at the doctrines on which the rule against natural justice is founded, and that is the doctrine of Audi Alteram Partem, together with the doctrine of Nemo Judex in Reju. And then we'll also proceed in this video to look at the elements on which the right to a fair hearing is actually premised. So, ladies and gentlemen, my name is Mutiava Conrad. I'm a lawyer and a private law tutor. And I encourage you, before we embark into our class, to subscribe to my channel. Also ensure that you like and share this video with your colleagues so they're able to benefit, but also very importantly, ensure that you turn on your notification. And also, students that are interested in private law tutorial classes, you can always contact us. Our number is down in the description box. You can call us and we can engage on you privately. We can have an arrangement. So let's start right away by looking at our topic known as natural justice. So basically, this topic is very fundamental, and it's really very important for any person to know about the right or their right to natural justice. Now, when you look at it, it is a broad concept. Okay, natural justice basically, in essence, is the fairness in which a person ought to be treated when making a decision which affects them. So there's always that aspect of fairness. Okay, so when we talk of natural justice here, we are meaning the fairness within which you must treat someone every time you're making any decision that attaches to such a person. There's that degree of fairness that such a person must be treated with, and that is basically what natural justice is all about. But it's also important to note that basically the concept of natural justice is premised on certain fundamental principles. Okay, so these principles are actually what in Latin we call the rule of Nemo Judex in Reju, and also secondly, the other principle on which natural justice sits is what in law is known as Audi Alteram Partem, which of course we are going to be looking at these two principles a little bit more in detail. We are going to look at one at a time. And basically, it's also important to note the legal framework within which the principle of natural justice operates. When you look at so many constitutions of so many countries around the world, and even under common law, this doctrine is really incorporated in most of the constitutions because it's a worldwide concept. It's not unique to a certain country. These are international concepts which are acknowledged and respected by all countries. But of specific interest is Article 28 of the 1995 Constitution of the Republic of Uganda. It actually provides for the right to a fair hearing. And then also of interest is Article 42 of the 1995 Constitution. When you look under that article, it actually provides that when you're making an administrative decision attaching to a person, it is very important that you actually give them a fair hearing. So even in administrative matters, you must give someone a fair hearing. And as we talked and as we looked at earlier, the right to a fair hearing actually encompasses a number of elements, and that of course includes the Audi Alteram Partem and also the Nemo Judex in Reju, which we are going to be looking at shortly in detail. And right away, let's start with the Nemo Judex in Reju rule, which is also translated to mean that no man shall be a judge in their own cause or in their own case. So basically, this is also a principle that governs the rule against natural justice, or the rule basically states that if you are a party, you cannot be a judge in your own cause. Okay, you cannot be a judge in your own case, meaning that you cannot be a person who is affected or the same person who is lodging a complaint, and then you're the same person again who is sitting in your own matter to determine it. So basically, that is what the principle of Nemo Judex in Reju is about. It's also important to note that this principle of Nemo Judex in Reju, which we also referred to as the rule against bias, basically has a number, it's divided into a number of aspects. It can be viewed at in a number of ways. The first aspect that encompasses the rule against bias is what we call actual bias. Okay, so bias basically can manifest itself in many instances. The first aspect is actual bias. So actual bias, here with actual bias, there is actually direct bias. Okay, there is direct actual bias. This is direct. For example, if let's assume you maybe applied for a visa, or let's say you applied for any documentation, let's say birth certificate in a public office or in an entity, and then the authority who is responsible for giving you the birth certificate actually refuses to give you the birth certificate simply because they have a natural dislike of you. They just don't like you, or maybe you've not appeared well to them, or they have not picked interest in you. So that is actual bias. It is direct bias. This is not normally the case. It's not a common form of bias, but it happens every single day. Then the other form of bias is what we also call presumed bias. So here, meaning that there are certain circumstances or there are certain instances where bias can actually be presumed. And what are those instances? Instance number one is where there is a direct pecuniary interest. So if a party has a direct pecuniary interest in a matter, then we will presume that actually there is bias. Okay, and these instances can include a good example that I can probably give you is if you are determining a matter, okay, and that same matter which is before you, you're the judge, but the matter also you have an interest in it. Maybe, let's say, financial interest. Maybe a matter has been brought to you to determine, but then also the dispute is about maybe the profits that a company before your court is supposed to share. And interestingly, you're one of the shareholders of that company. So you have a pecuniary interest in that matter that is before you. And as such, we say in law that there is a pecuniary interest. You have a pecuniary interest in the matter. And then the law, in such an instance, will presume that actually there is bias in the premises. Of interest, I would encourage you to go and look at an interesting case, and this is the case of Dimes versus the proprietor of the Grand Junction Canal. It's a very old case of 1852, volume 3, HLC, page 759. It's an old case, but it's very interesting. It will bring out the facts a little bit better. And basically here, Lord Chancellor Cottenham affirmed on appeal the Vice Chancellor's decree that Dimes could not obstruct the Grand Junction Canal's land. It transpired that the Lord Chancellor held shares in the Grand Junction Canal, and the House of Lords reversed the Lord Chancellor's decree, and Lord Campbell went on to agree, and he made really a very interesting observation and judgment on the same. So again, you're seeing here how that pecuniary interest comes in, where court will presume that there is actually bias if you have a pecuniary or financial interest in a certain matter. So let's proceed, and we look at another aspect of presumed bias, and that is basically the non-financial interest, or what we also call the promotion of the cause. So it could also be, in certain instances, that you may be promoting a certain cause. This cause may actually be, it may not even be financial. You may not have a financial interest, but you're championing a certain cause, and we will go on to actually presume that there is bias in such an incident, and in such a circumstance, or in such an instance. Of authority, I'm going to encourage you to look at a very interesting case of R versus Bow Street Metropolitan Spedientiary Magistrate Ex parte Pinochet Ugarte. It's number 2 of 2000. This is volume 1 SC, page 119. And basically in this case, Lord Hoffman, one of the judges in the case, was in the majority of a decision which was a 3-2. Following the decision, Pinochet, who was actually the former president of Chile, discovered that Lord Hoffman was an unpaid director and chairman of a charity which was controlled by Amnesty International, who had joined the action in order to seek Pinochet's extradition. Now, as a result, it was alleged that this link gave the appearance that Hoffman may have been, biased against Pinochet. Very interesting. In the ensuing hearing, the House of Lords, the court set aside their previous decision on the basis of the principle that a man should not be a judge in his own cause, and as such, a judge's decision would lead to promoting a cause in which he was involved. So again, you're seeing here court trying to apply the principle of promotion of a cause in which you're involved. So every time there is a promotion of a cause in which one of the parties that is hearing a matter is actually involved, then there is actually presumed bias. It is one of those aspects where we'll say that there is actually bias, and that bias will always be presumed. So that's very important to note. Now, there is also another aspect which we call appearance, okay, of bias. So what we call apparent bias. Okay, so there are situations where there could be an appearance of bias. Okay, a bias is appearing. You can see it, or what we also call apparent bias. Now, for this aspect, okay, there is a test that we will always look at, and that test was clearly laid down in the case of Porter versus Magil. It's a case of 2001 UKHL, page 67, and the test basically is, open quotations, and I quote, the question is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was actually biased. So here we look at a fair-minded person who has all the facts. Okay, if they were standing aside, would they honestly say, would they really conclude that actually there is an appearance of bias? And if the answer is yes, then the test is satisfied, and then in law we say there is apparent bias. And of course, if the answer is no, then of course the test is not satisfied. Let's now proceed to give a case that will illustrate the concept of apparent bias. A very interesting case of Hannan versus Bradford City Council. It's a case of 1970, All England Law Reports, page 690. And the brief facts of this case were that Hannan was a schoolmaster who absented himself and refused to return to work. Now, in December 1967, his employment was terminated by a meeting of school governors. In January 1968, a council staff subcommittee met to consider whether the council should prohibit his dismissal. It decided not to do so. It decided not to dismiss him. 3 of the members of the subcommittee were actually governors. Although they had not attended the meeting in December 1967, and the Court of Appeal went on to hold that as the 3 governors had sat on the staff subcommittee, this gave rise to the possibility of bias. Okay, so again, we are seeing court applying this apparent bias. Okay, so and we are seeing court presuming it to be in operation, and court holding that actually there was bias. And remember, we already said that bias is one of the doctrines on which natural justice sits. The moment there is bias, then in law we'll say that there wasn't natural justice or the observation of it in the premises. Let's now proceed, ladies and gentlemen, to look at the other principle governing natural justice, which is the Audi Alteram Partem rule, or the doctrine of Audi Alteram. And basically, Audi Alteram Partem basically means the right to a fair hearing. Okay, in essence, that is what it means, the right to a fair hearing. The right to a fair hearing is a concept on which natural justice sits. The moment you do not give any person the right to a fair hearing, then we cannot say in law that there has been observance of the rule of natural justice. It's very, very important to note all these 2 principles must be in play for us to say that there is natural justice. The observation of the Audi Alteram Partem rule and also the observation of the Nemo Judex in Regio rule. Both of them must be into play. And again, for the Audi Alteram Partem, which we said means the right to a fair hearing, here Again, authority can be found in so many constitutions around the world, but specifically under the Ugandan constitution. Again, I invite you to look at Article 28, which provides for the right to a fair hearing, and also Article 42 is still authoritative, which provides that in making decisions of an administrative nature, compliance to fair hearing must be adhered to. It's also now important at this juncture to understand what the effect is. Okay, very, very important. You have to know what is the effect of non-observancy of natural justice. Okay, what if a tribunal, what if a person does not observe natural justice? What is the effect of the decision? What happens to the decision? And the effect is that such a decision arrived at in violation or without observing natural justice is actually null and void. It's wrong. It's as if it never existed. It's just a total waste of time. It will not be considered lawful. It's unlawful. It's null and void. Authority for that position can definitely be found in the case of Matovu and two others versus Severi and another. It's a case of 1977 High Court Bullet, page 174, and the court went on to hold that a decision arrived at in violation of a right to a fair hearing, the rule of natural justice, is null and void to the extent of its nullity. Very interesting there. Let's now go on to look at the elements. Okay, so this rule, which we call the rule or the right to a fair hearing, actually has certain elements. Okay, it is not an abstract concept in itself, but it is premised on certain fundamental elements, which must either all of them be in place or at least majority of them must be observed. So when we talk about a right to a fair hearing, and I really want to emphasize this, there's nothing so sacrosanct, there's nothing so fundamental as the right to a fair hearing. There's nothing so important as natural justice. If there's anything in this world that you should really never violate, it has caused so many wars, so many disagreements. It is the reason why most of the citizens of this globe are suffering. And I always encourage all you citizens, all you lawyers, all you fair-minded people of this world to always observe the right to a fair hearing. The doctrine of natural justice. It's very, very important in a democracy. It's something that is very sacrosanct, something that we cannot derogate from. Actually, under the 1995 Constitution of Uganda, this is one of the rights you can never derogate from. Under Article 44, when you look under Article 44, Clause C of the 1995 Constitution of Uganda, it's a non-derogable right, meaning that you may do away with all the other rights, but the right to natural the right to natural justice, the right to a fair hearing, the right to being subjected to a decision to a tribunal that is not biased is non-derogable. You can't derogate from it. You cannot do away from it. That is the Constitution of Uganda. You cannot. It is sacrosanct. It is non-derogable. Very important to note. And under so many constitutions around the world, the same applies. I'm not sure though if that is the position under common law, because shortly we're going to be discussing a case where actually the courts in Britain have held that this right can actually be derogated from. But the Ugandan position is that no, this is a non-derogable right. So let's proceed, ladies and gentlemen, to look at the elements of a fair hearing. These are really very important to note. Now, the elements of a fair hearing, the first element we are going to be looking at is the right to know the adverse evidence. Okay, so this right pertains to a right to a fair hearing. You must know, okay, the adverse evidence. What does the other party have? If they are charging you for an offense, okay, let's say you've been charged for murder or for theft or any other offense, think about it, you have that right to know the adverse evidence. What evidence does the other party know? What evidence does the other party have? What evidence are they going to adduce against you? This is really very important, and it has actually been provided for under the 1995 Constitution of Uganda. I encourage you to look at Article 28, Clause 3b, and that article provides that a person who has been charged for a criminal offense or charged for an offense shall be informed immediately in a language they understand of the nature of the offense. So again, you have to inform this person what is the nature of the offense, and informing that person the nature of the offense also includes in it, the concept also includes knowing the adverse evidence that the other party actually has. And this principle has actually been long also ingrained under common law. And I encourage you to look at the case of Kanda versus Government of the Federation of Malaya. It's a case of 1962 SC, page 322. And Lord Denning, basically in that case, puts forward a very interesting observation which forms the holding of that court, where Lord Denning actually stated that the right to a fair hearing is not complete. It is non-existent unless the other party is afforded an opportunity to know what evidence has been given and what statements have been made that are affecting him or her. So very, very important. And then secondly, also important to note that there is an exception to this principle under common law, which is in matters of national security. So in matters of national security, according to decided cases in Britain, which is not the position in Uganda, this right can be derogated from. And I encourage you to go and explore the case of Ara versus Secretary of State for Home Affairs, ex parte Hossein Ball. It's a case of 1977, volume 1 WLR, page 766. The courts in Britain, specifically the House of Lords, has actually held that in matters of national security, this right can actually be derogated from. I doubt that that is the position under the Ugandan Constitution, considering Article 28, 42, and most especially Article 44, which makes this right non-derogable. Let's now proceed to look at the second element of a right to a fair hearing, and that is the right to make representation. So yes, the right to a fair hearing also encompasses in it the right to make representation, and the rationale is to give the person affected by a public decision the opportunity to influence it before actually a decision is made. Okay, it's important that I give my representation so that you're able to put on a weighing scale to determine the proper or the right position, and that is the rationale of making representations. And authority for that position, I encourage you to go and look at the case of R versus Ware Valley District Council, ex parte Binks. It's a case of 1985, volume 2, All England Law Reports, page 699. And it's a very interesting case there that you should go and look at. And basically the facts were that a lady who owned what we call a hot food takeaway caravan was of course told or asked to take away her caravan, and that decision was quashed. And the reason that court relied on really to quash that decision was that she had not been given an opportunity to be heard, and then that secondly, she had not been given prior notification to take away her hot food caravan, and then lastly, that in arriving at the decision maker had actually not given reasons for that decision. So it's a very interesting case, and those were basically the three holdings of court. Let's now proceed to look at the third element, and that is the right to have sufficient time to prepare a defense or answer a case against him or her or against the person who is accused. This is really very important, and it attaches to a right to a fair hearing. We cannot say that there is a right to a fair hearing if the other party has not been given time to prepare their defense, to prepare the explanation, to answer to the charge. Okay, they have to be given time so that they can come up with a very convincing or good defense if they have any. So sufficient time to prepare a defense must be given, and actually this is also provided for under the 1995 Constitution of the Republic of Uganda. I encourage you to look at Article 28, Clause 3C of that Constitution, which provides that adequate time and facilities must be given to prepare a defense. And also a very interesting case which was passed recently. I encourage you to go and find it and ensure that you read it in detail. And this is the case of Human Rights Awareness and Promotion Forum versus Attorney General and the Commissioner General of Prisons. Very interesting case. It's miscellaneous cause number 81 of 2020. You can find it online. It basically goes on to explain what amounts to giving sufficient facilities to a person to prepare their defense. It's a very interesting case. I encourage you to go and read it. Let's now proceed to look at this element number 4, and that is the right to cross-examine adverse evidence. So that right basically is to the effect that the right to a fair hearing also encompasses your rights to actually cross-examine the evidence brought by the person or the party who is bringing charges against you or who is instituting a suit against you. So if they bring evidence, you have a right to cross-examine, to poke holes in it, so that you're able to show the validity, whether indeed such evidence is valid or not. Okay, this will help court to actually analyze and evaluate such evidence, and it will help court to arrive at a right conclusion. Or it doesn't have to be court, it can be any tribunal or any person who is making a decision. So this is really very important, and I encourage you again to go and look at Article 28, Clause 3G of the 1995 Constitution of Uganda, which provides that every person who is charged with a criminal offense shall be afforded facilities to examine witnesses and to obtain the attendance of other witnesses before the court. So this is also intended to allow the other party to actually do a cross-examination and to go on and interrogate these witnesses more, so that such evidence, if false, many holes would be poked in the same. And also to add on that, for your private reading, you can also go and read the case of R versus Hull Prison Board of Visitors, Ex parte Saint Germain and others. This is case number 2 of 1979, volume 3, Old England Law Reports, page 545. It's also authoritative on the same. The other fifth element of the right to a fair hearing is the right to an oral hearing. So this is also very important. A person whom allegations have been brought against also has a right to oral hearing. But it's important to note, ladies and gentlemen, that the oral hearing here does not necessarily mean that you must come and give oral evidence. It is also sufficient that you can be required to put in something written. So you cannot say that, oh no, they did not allow me to come and speak. No. You know, the right to an oral hearing also encompasses in it a right to written submission. So if you're required to write something in response to the allegations, it is sufficient enough. And I encourage you to go and look at the case of R, that is West versus Parole Board. It's a case of 2005 UKHL number 1. You go and look at it. It actually discusses that element. Let's now proceed to look at the right to legal representation. So this is very important, really. You have a right both under the Constitution and even case law, even under common law. This right to legal representation has been recognized for so many years. So you have a right to a lawyer, and always hire a lawyer, always ensure that you contact us to represent you. It's your right. Okay, so it's your right. It's sacrosanct. It's under the right to a fair hearing. You have it, and specifically under Article 28, Clause 3D of the Constitution, it's authoritative on that. And I also encourage you to go and look at also Article 28, 3E. Again, is authoritative. But let's interrogate these articles a little bit more. When you look at Article 28, Clause 3D, it provides that every person charged with a criminal offense shall be permitted to appear before court in person or at a person's own expense by a lawyer of his or her choice. So you're seeing the Constitution allows you to have a lawyer to represent you. But also Article 28, Clause 3E provides that in the case of any offense which carries a sentence of death or imprisonment for life, the state must actually give you a lawyer to represent you if you cannot afford your own. Okay, so you realize how sacrosanct this right to representation or legal representation actually is. The Constitution recognizes that for certain offenses which carry a maximum penalty of death, you're entitled to legal representation, even in circumstances where you actually cannot afford this right. The Constitution goes on to mandate or to make it compulsory for a state to go on and give you a private lawyer. So that's how important really this right is. Let's now proceed to look at another element of the right to a fair hearing, and that is the duty to give reasons for a decision. So, ladies and gentlemen, the duty to give reasons for the decision is very, very important, and it's also one of the elements. And I encourage you to go on and look at an interesting case of R versus Secretary of State for Home Department ex parte Al-Fayed and another. It's a case of 1997, Volume 1, All England Law Reports, page 228. Before I take you through the brief facts of that case, the Constitution, remember, it's the supreme law, so we'll first look at the Ugandan Constitution before we even look at the common law. Common law is really secondary, where the Constitution has addressed a certain issue. So I encourage you to go and look at Article 28, Clause 6 of the 1995 Constitution of Uganda, which provides that a person tried for any criminal offense or any person authorized by him or her shall, after the judgment in respect of that offense, be entitled to a copy of the proceedings upon payment of a fee prescribed by law. So again, the Constitution is saying that if a judgment is passed, you're entitled to a copy of the proceedings. And of course, it's expected that the copy of the proceedings has the reasons for the judgment. Because when we are drafting, and we shall look at that in civil procedure, the contents of a judgment, one of the requirements under Ugandan law when judges are drawing or drafting judgments is that the judgments must have a reason. Okay, for the conclusion, you must include the reason. How did you arrive at what you are arriving on? So it's important, the Constitution allows you to have a copy of a judgment on paying a certain small fee. So let's now proceed to the facts of R versus Secretary of State for Home Department ex parte Al-Fayed and another. So basically in this case, Al-Fayed had applied to office to actually get a document, I think, which was he had applied for naturalization, and basically his application was rejected. No reasons were ever given, and he applied to court, and court entirely agreed that the body that was supposed to hand him the documents actually had an obligation to at least give reasons why they denied him such authorization. And court went on to state that this would help to facilitate, or rather to inform, such a person or such a committee when they are arriving at a decision. Because if they had given him, Al-Fayed, reasons why they rejected his application, then Al-Fayed would reply, giving his position, and probably this would give more information on which the committee would rely to make a judgment. So ladies and gentlemen, that is all for today's class. Again, I encourage you, ensure that you subscribe to this channel, turn on your notification, share with your colleagues so that they are also able to benefit. It's important to share with them. And then also lastly, and very importantly, and we keep on encouraging students to ensure that you get onto our tutorial program where we are able to tutor you. You're able to have the experts come to tutor you. There's so much, again, I insist, the law is very wide. There's so much that is always left out because of time and also other factors. But if you engage us privately, we're able to take you in material detail. We are able to unpack the law together. We are able to demystify these legal concepts. And it has been proven that students that really get onto our tutorial program outperform their fellow colleagues even in law school, and it has a long-term implication. Grades really matter. I keep on emphasizing this, so ensure you have the proper mentorship from the word go. Involve the experts. They can always make it simple for you. Thank you very much, ladies and gentlemen. Once again, my name is Mutiawa Conrad, a lawyer and a private law tutor. We meet again in another session. Bye-bye.